seated. Council ready for our second case of the day. You may proceed.
May it please the court. My name is Richard Suma. It's a pleasure to be here to represent the appellant in this case, Mr. Jose Degracia. Mr. Degracia was convicted of 1 count of trafficking in cocaine, 1 count of conspiracy to traffic in cocaine. I intend to reserve 3 minutes for rebuttal. I certainly will not be able to address every issue that was raised in the brief, so without abandoning any issues, I'll try to concentrate on 2 of them. The first would be our argument pertaining to the constitutionality of the sentence imposed for these 2 offenses. Our argument begins with the case of Chacon v. State. In our view, Chacon, the Florida Supreme Court deemed that it must, by judicial construction, modify the statute possession of cocaine by inferring a mens rea element of knowledge of the illicit nature of the substance. Subsequently, in direct response to that, the legislature enacted Section 893.101, which clarified that the legislature really did mean that knowledge of the illicit nature of the substance is not an element of the offense. It also made lack of knowledge an affirmative defense. But our issue focuses on the elements, which does not include knowledge of the illicit nature of the substance of the offense. So in our estimation, and we believe correctly derived from the clear language of Chacon v. State, absent this mens rea element, all drug offenses under Chapter 893, including those for which appellant was convicted, are now strict liability offenses. And further, from the Chacon case, we derive the rule that it is a violative of due process to impose a felony punishment for any drug offense now under Chapter 93, but specifically here trafficking or conspiracy to traffic.
So you don't think it matters that the legislature just changed the burden of proof? I mean, really, still,
well, you know,
if your client has no awareness of the illicit nature of the substance, then your client cannot be convicted.
I think that's a reasonable argument that the legislature changed the burden of proof, but that's not the argument that we're making today. In fact, I do note that a couple of other district courts have already rejected that argument. But our argument is more narrowly focused in that just referring to the elements, there is no mens rea element. And we also concede that the legislature has the sole prerogative to determine what the elements are. So the elements of this offense do not include the mens rea requirement. And Chacon v. State clearly states that absent this mens rea element, in that case, possession would be a strict liability offense. And the same rationale applies to trafficking or sale, delivery, because subsequent cases from the Florida Supreme Court, of course, have confirmed that the analysis advanced in Chacon applies to sale and delivery as well, and the language of the statutes are identical. Plus, moreover, now we have the clarifying statute that tells us that there is no mens rea element. Now,
so I know from your brief that you're arguing thus without the mens rea requirement, the penalty is violative of due process because it's too harsh, correct?
That's correct. And we get that from the language in Chacon, but of course Chacon got that from a number of United States Supreme Court cases, including United States v. Morissette, Staples v. United States, right, which say imposition of felony punishment is incongruous with an offense that requires no criminal intent. And that, I do believe, is what we're dealing here with now.
So your argument is that by deleting the requirement that knowledge of the substance as an element makes it a non-mens rea crime.
Exactly, Your Honor. And we were able, this is a quite unusual circumstance. In fact, we think it's unprecedented in the history of United States law, where a legislature has expressly repudiated the efforts of the judiciary to save the constitutionality of a statute by implying a mens rea element. Never seen it before.
The Florida legislature has such trust in the Florida Supreme Court to help them that way.
Yeah, so it's not unusual that, therefore, that I cannot cite a case where a court has actually reduced the sentence along this principle.
Right, I understand your argument, and I certainly appreciate it. And so I guess my follow-up question is, where does the other shoe fall? What's the maximum penalty? Let's just say we were to adopt your argument.
Yeah, no, I think
would trafficking in cocaine become a misdemeanor?
Yes, that's my position.
Right.
Yeah, and I have, I think I have found a very interesting case, United States v. Wolf, which is cited in my brief, and it's a good example of the analysis right on the precipice of where we want to go with a reduced sentence. In that case, the defendant was indicted for selling a necklace made of parts of an endangered and protected species, talons of protected birds. And the defendant moved to dismiss the indictment. He said, Your Honor, we cannot suffer felony punishment as we are subjected to because there is no mens rea requirement in this statute. And the district court in the Sixth Circuit Court of Appeals, thinking right along the lines that I'm thinking, said, no problem, let's have a trial. If he's convicted, we'll impose a misdemeanor punishment under the misdemeanor portion of the statute. The government wasn't really happy with that because if he was convicted and sentenced to a misdemeanor, there would be nothing to appeal under double jeopardy principles. So the government preferred that the court actually dismiss the indictment so the government would have something to appeal. And that's what the district court did. They dismissed the indictment, and then the case went on appeal. And guess what? The Sixth Circuit Court of Appeals agreed with the lower court and specifically held that felony punishment for a strict liability offense would violate the due process clause of the federal Constitution.
And in that case, was a lack of knowledge and affirmative defense?
No.
I mean, because don't you think that
Not that I'm aware of.
Don't you think that is I mean, it's kind of like to be convicted of any crime, your client has to be sane, correct?
Has to be
Sane.
Sane?
Right.
Yes.
But the state doesn't have to prove sanity. The defense has to raise it and put it in issue. It's, in essence, an affirmative defense. So it's not that we're prosecuting people or putting people in jail when they are insane. We're just saying that the defense has an affirmative defense of insanity if that's the case. I mean, you know,
I see your point, but
You don't think constitutionally there's a distinction?
excuse me.
You don't believe constitutionally there's a distinction between a burden shifting of the element and an elimination of the mens rea element?
I do think constitutionally there is a distinction. But in that case, the law would be acknowledging that there is an element, the burden of which has been shifted to the defendant. Because of this statute that we're dealing with, there is no element, the burden of which has been shifted to the defendant. Because an affirmative, I mean, when you're talking about affirmative defense, one may avail themselves of affirmative defense or not. But the question is, what is the criminal conduct? What is the criminal offense? What are the elements that comprise the criminal or unlawful conduct? And in that regard, what I'm suggesting is really you have to put on blinders, because whether or not the defendant has knowledge of the illicit nature of the substance or not is not a part of the criminal conduct. The legislature has told us that. In other words,
The criminal conduct is possession of a substance. That substance happens to be cocaine. The amount of that substance happens to be over 400 grams or 28 grams, making it trafficking.
for the trafficking offense, and
no mens rea.
ultimately the state proves that substance is cocaine, whether the defendant knew it was or whether the defendant did not know it was, is really irrelevant in the legal sense now.
Well, as I understand what you're saying then, in response to Judge Hawks' question, a person has 400 grams of a substance. He has no idea what it is.
sells it for $19,000.
People are offering him money for it. he's arrested, the substance is tested for cocaine. He could make an affirmative defense of lack of knowledge. He thinks he never knew it, but he just doesn't. He just doesn't. He chooses not to make that affirmative defense.
Right.
You're saying that under the Due Process Clause, he cannot be sentenced as a felon.
That's correct, Your Honor. It may not seem just or fair, but then we're talking about policy considerations, and I can't discuss those policy considerations. The court can't discuss those policy considerations. I'm just dealing with the law as it has been presented to us by the legislature. And it may even seem anomalous that the person doesn't have more of a guilty mind than
Sure, I
we
understand.
would want. But
and I understand your argument, I think, perfectly well. So now I'm trying to reconcile it with those cases in the United States Supreme Court, as I recall, where they said states can shift the burden of proof regarding voluntary intoxication, regarding sanity. How can the federal courts have held that you can shift those burden of proof?
I don't know, but I do know that there are cases that are more on point, which deal with knowledge of the nature of substance. Like we're going back to the Morissette case. The person was picking up abandoned shell casings, and the question was, did he have knowledge that, that property belonged to someone else? And those types of cases seem more on point, and we have to go with the specific over the general when you're talking about sanity.
Well, didn't that case spend a lot of time explaining why he would have assumed what he assumed? I mean, that he was, they went in great descriptions of this empty field. They were scattered about. There was no, I mean, just pointing how, in essence, a reasonable person would conclude that those casings were free to pick up.
Yeah, but the question I have is whether all that discussion is really germane to the court's conclusion that without a mens rea element, the statute would be unconstitutional. I'm going to be into rebuttal time, and I pray that the court would ask the state to explain the United States v. Wolf case to see if that represents a correct statement of the law and whether it should apply. I know it's not controlling authority, but it's persuasive. And
so your argument is we should hold that the Supreme Court in Chicone tried to save the constitutionality of the statute. The legislature repudiated the Supreme Court and said, no, knowledge is not an element. And then we hold, well, by doing so, legislature, you've rendered it unconstitutional, which was the fate the Supreme Court tried to save you from.
No, it's not unconstitutional, if I may respectfully correct you, Your Honor, because strict liability crimes are not unconstitutional.
As felonies.
As felonies, yes. Thank you.
May it please the court, Brian Jordan representing the state of Florida. Appellant's argument is actually controlled by this court's decision in Harris, wherein this court held the legislature's elimination of knowledge of an illicit nature of a substance does not violate due process under either the Florida or federal constitution. Even more so, appellant's premise underlying his argument that, as it now stands, possession, trafficking, and cocaine is a strict liability offense is erroneous, because lack of knowledge is affirmative defense. Interestingly, in Chicone, where the Supreme Court read into a knowledge element, later on, looking past those pages on which appellant relies, they specifically rejected the state's argument that lack of knowledge is an affirmative defense because the legislature did not provide for one. The legislature has provided for one now. And speaking to appellant's reliance on United States v. Wolf, what is interesting is that case really defeats his argument. At issue in that case was the Migratory Bird Treaty Act, which is a strict liability crime. However, appellant has overlooked the fact that has not looked into why it's a strict liability crime. It's because lack of knowledge is not a defense. Doing the act equals guilt. I didn't know means nothing. A true strict liability criminal statute, and this an easy one to identify, is statutory rape. Lack of knowledge, not a defense. In this case, the legislature has specifically provided with possession and trafficking of a controlled substance that lack of knowledge is an affirmative defense. It is this court held in Harris that it's within the legislature to do that. It does not violate due process. The state asks that this court affirm appellant's judgments and sentences. Thank you.
Thank you very much. I think it's important to note that the opinion in the Harris case does not control because a different claim was raised there. And in the Harris case, the court said that Section 893.101 does not violate due process. We are not claiming that it violates due process.
You're claiming it's a misdemeanor.
Right. It is constitutional. It creates a strict liability law, but we're claiming the penalty, therefore, is unconstitutional. In addition, in Harris, the type of due process claim raised was the burden-shifting type of claim, and we're not maintaining that claim either. With respect to the state's reference to the affirmative defense, I can only reiterate that, one, I think it's improper to rely on an affirmative defense to say that places knowledge of the illicit nature of the substance at issue. For one thing, let's suppose we had a case where a defendant did raise the affirmative defense, and the jury finds him guilty. Now, what may we deduce from the jury's verdict? Does that mean that the state proved beyond a reasonable doubt that the defendant had knowledge of the illicit nature of the defense? No, because like when we present a defense of self-defense, the jury is instructed if the defendant presents evidence of self-defense, prima facie evidence, then the burden shifts to the state to prove beyond a reasonable doubt that he did not act in self-defense. But the jury's verdict doesn't tell us whether they found him guilty because the state proved beyond a reasonable doubt that the affirmative defense was not applicable, or the jury found that the defendant did not raise a prima facie case to shift the burden to the state. So a verdict of guilty is not tantamount to a finding that the defendant, beyond a reasonable doubt, had knowledge of the nature of the substance. So we would ask that...
Would you mind commenting, if Your Honor, Judge, would you allow him to answer?
Sure, absolutely.
Would you mind commenting on the state's assertion that under your analysis then, those sexual assault crimes, formerly known as statutory rape, where an element of the crime is the victim is under a certain age,
Right.
is not a defense.
That is certainly true, and I think we explained in our brief that with respect to sexual crimes against minor children, there's a long-standing historical exception to this rule, which is derived from the common law, and because of the long-standing exception, that's recognized by itself, sui generis, as exception to this rule. But the controlled substance offenses do not fall within that exception because they are creatures of stature, relatively modern, and in fact, if you go back to the history of when they were first enacted, they were considered public welfare offenses in the nature of health and welfare regulations, and were, at the inception anyway, mainly misdemeanors. Thank you.
Thank you, counsel. Call our next case.